Failure to identify. Plaintiff/appellant's right to be secure in his papers without reasonable articulable suspicion of a crime was well established at the time of the subject incident. As per TX Code 38.02, appellant would have had to have been lawfully arrested and either failed to identify or produced false identification after being lawfully arrested. Given that there was no reasonable predicate crime alleged, and, again, the matter was pure retaliation to Amendment I, therefore any reasonable law enforcement public servant would not proffer failure to identify as the sole reason to arrest, such is not reasonable given that no predicate crime existed, and appellant was not lawfully arrested. There is no arguable probable cause for an arrest based solely on failing to identify as such is well established by Amendment 4 and supported by Terry and the statutory language of TX Code. See also Brown v. Texas, 443 U.S. 47, 1979, 1. Disturbing the peace, the court will take mandatory judicial notice of the incessant inaccuracies by the adjunct to the Article 3 tribunal within the report and recommendations, ROA.22-4065.3.489-500 ESP 496, where said attempted to create a disorderly crime based upon appellant's protected speech. Appellant's right to speech and to verbally criticize police was well established at the time of the subject incident. Though it was the adjunct to the Article 3 tribunal that brandished the charge of disturbing the peace, it is worth discussing as such an assertion fails to meet reasonable suspicion for a detainment nor even arguable probable cause. Appellant was in a parking lot bereft of any civilians that could have possibly created a riot or public disorder and was in the process of recording matters of public interest for public dissemination, as lawfully permitted to do and for which there exist sacred protections found within Amendment I of the United States Constitution. The assertion by the magistrate is not only biased, but simply ludicrous, unrealistic, and demonstrative of unconscionable incompetence in law and at law. 1. Brown v. Texas, 443 U.S. 47, was a United States Supreme Court case in which the court determined that the defendant's arrest in El Paso, Texas, for a refusal to identify himself, after being seen and questioned in a high-crime area, was not based on a reasonable suspicion of wrongdoing, and thus violated the Fourth Amendment. Premise I. The inferior court erred in demonstrating partiality in favor of the police. The appearance of partiality is of chief concern. Berger v. United States, 255 U.S. 22, 41 S.CT 230, 65 L.ed. 481, 1921. The court officers therein placed the police in entirety upon a pedestal and went insofar as to manufacture non-existent crimes based on appellant's assertion of right to the claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S. 230 F. 2D 486, 489. This allegiance to the police prejudiced the court against appellant whereafter all orders and findings are made without due process and based on bias. A right to an impartial judge is so basic to due process that courts can never treat its infraction as a harmless error. Chapman v. California, 386 U.S. 1823, 1967. Axiomatic, any orders made outside the limitations of due process, which requires a fair, unbiased, disinterested third-party referee, are void of initio, nullities, of no force and or effect. The bias demonstrated by the inferior court officers constitutes a reversible error which should also require the disqualification of the judge and termination of the magistrate, a creature of statute. The magistrate, with no first-hand knowledge, brought forth a multiplicity of inaccuracies while utilizing descriptive language that was not true. ROA.22-40653.240-281, the magistrate attempted to use words of art to paint an unrealistic image of the occurrence, claiming appellant was yelling when appellant did not yell as provable on video evidence, claiming appellant was angry, belligerent, and rude, which is not true and, even if such was true, still is protected speech that doesn't warrant an attack on appellant's person nor institute total police immunity. The magistrate defended the actions of Laird in ripping the recording device from appellant and throwing it on the ground as standard procedure when handcuffing a perpetrator, but failed to recognize that no reasonable, articulable suspicion of any crime ever existed that would allow for lawful detainment. ROA.22-40653.390, the detainment was unlawful and in direct contravention to well-established law. The court was grasping at straws, to coin the commonly understood idiom for a person trying to rationalize a wrongdoing without any true substantiation, to support the actions of Laird that were and are in direct violation of well-established law and in doing so demonstrated unconscionable bias rendering the order deficient of due process. Premise 2. The inferior court erred in failing to enact/enforce appellant's protections of press and, instead, argued against the well-established right, openly mocking appellant as a news entity despite the First Amendment right to free press, which protects anybody and everybody who seeks out stories of public interest. The right to film in public is well established. Smith v. City of Cumming, 212 F.3d 1332, 1333, 11th Circle 2000, finding, in a case involving citizens videotaping police, that, he First Amendment protects the right to gather information about what public officials do on public property, and specifically, a right to record matters of public interest. This court's own decision in Turner v. Driver, 848 F.3d 678, 688 to 689, 5th Circle 2017, fully supports the right to record police. The court will take judicial notice of Irizarry v. Yahia, No. 21 to 1247, 10th Circle 2022, which expounded on the protections of Amendment I to enjoin police from any form of retaliation for the assertion of press. In this matter, Laird actually grabbed appellant's recording device and threw it to the ground, where in Irizarry, the mere act of preventing recording by way of shining a flashlight constitutes an actionable offense. What was inflicted upon your appellant was nothing short of a schoolyard bully, drunk with fictitious power, who did not like appellant's assertion of well-established right and fully retaliated by unnecessary force, and, instead of supporting the well-established rights of appellant that are clearly protected by law and constitution, the inferior court officers cheered on the bully, supporting the clear retaliation to press, openly mocking the well-established right and the First Amendment to the Constitution for the United States, as well as prior decisions of this and other courts. ROA.22-40653.280, 467. Amendment I to the Constitution for the United States mandates prohibition on the government, or any agent therein, from impairing the freedom of press, which includes video recording in public and from public, which has been well established as a protected right. In Brandsburg v. Hayes, 408 U.S. 665, 1972, the Supreme Court noted that without some protection for seeking out the news, freedom of the press could be eviscerated. ID at 681. Plaintiff was in public, in a parking lot paid for through public funds, which are areas that have historically been open to the public for speech activities. McCullen v. Coakley, 573 U.S. 464, 476, 2014. Upon initial contact by Laird, it was obvious that appellant was recording, and Laird articulated knowledgeable understanding that appellant was recording, having made clear that the purpose for police contact was specific to the fact that appellant was video recording. See Laird's body cam video. Perhaps the greatest weapon utilized against police corruption and police misconduct in the past century has been the camera, which has brought to justice more bad actors in law enforcement than any weapon ever could. This is further demonstrated by judges' refusal to allow cameras in the public courtrooms to record public process. We should all be weary when the government controls the record, hence the importance of Amendment I. Laird, seeing a camera as a threat, attacked appellant, throwing appellant's recording device to the ground, then created fictitious, unrealistic, and unreasonable assertions of crimes with the intent to suppress the assertion of free press. The contact was made based on the fact that appellant had a camera, and the statute, though misapplied, was attempted and asserted unconstitutionally based upon appellant being involved in free press, as a means to chill appellant's assertion of right, thusly causing harm to appellant by threat to armus, and physical attack as a means to suppress a First Amendment protected right to which appellant was clearly involved, and the inferior court wholly supported this action. ROA.22-40653.280, 467. Axiomatic, the act of making an audio or audiovisual recording is necessarily included within the First Amendment's guarantee of speech and press rights as per ACLU of ILL. V. Alvarez, 679 F.3d 583,595, 7th Circle, 2012. The Seventh Circuit went on to hold that audio and audiovisual recording are media of expression commonly used for the preservation and dissemination of information and ideas, and thus are included within the free speech and free press guarantee of the First and 14th Amendments. Laws that restrict the use of expressive media have obvious effects on speech and press rights. The Supreme Court has voiced particular concern with laws that foreclose an entire medium of expression. The act of making an audio or audiovisual recording is necessarily included within the First Amendment's guarantee of speech and press rights as a corollary of the right to disseminate the resulting recording. The right to publish or broadcast an audio or audiovisual recording would be insecure, or largely ineffective, if the antecedent act of making the recording is wholly unprotected, as the state's attorney insists. By way of a simple analogy, banning photography or note-taking at a public event would raise serious First Amendment concerns. A law of that sort would obviously affect the right to publish the resulting photograph or disseminate a report derived from the notes. The same is true of a ban on audio and audiovisual recording. ID at 595-96, internal citations omitted. In 2017, this very court concluded similarly in Turner v. Driver. While appellant's initial news story was about condition of the patrol units and government spending thereupon, it quickly became about police misconduct and now about judicial misconduct. Despite it being clear that appellant was engaged in constitutionally protected journalistic activities and was on public grounds with no signage or anything else to say otherwise, Laird proceeded to harass and attack appellant by manufacturing crimes through the misapplication of an applicable statute as a means to suppress appellant's assertion of right. Retaliation for First Amendment protected activities and a loss of First Amendment freedoms, for even minimal periods of time, unquestionably constitutes irreparable injury. Elrod v. Burns, 427 U.S. 347, 373, 1976. The inferior court refused to apply these constitutional protections and were more concerned that appellant was rude, which somehow magically granted the police the authority to attack the press. He First Amendment protects film as a medium and the act of filming, as there is no fixed First Amendment line between the act of creating speech and the speech itself. Keenan v. Tejada, 290 F.3 D. 252, 259, 5th Circle, 2002. Premise 3. The magistrate, as mentioned above, in the biased tirade against appellant, attempted to create a crime from appellant's speech, implying that appellant's speech was rude and therefore appellant was open to attack by the government and the government then immune from constitutional redress. The magistrate, and thus the judge, erred in converting constitutionally protected speech into probable cause for a criminal arrest/detainment/attack and erred in failing to apply well-established constitutional protections. The U.S. Supreme Court has stated that no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Cooper v. Aaron, 358 U.S. 1, 78 S.C.T. 1401, 1958, see also in Re Sawyer, 124 U.S. 200, 188, U.S. v. Will, 449 U.S. 200, 216, 101 S.C.T. 471, 66 L. ed., 2d. 392, 406, 1980, Cohens v. Virginia, 19 U.S. 6 Wheat, 264, 404, 5 L. ed. 257, 1821. The inferior court erred and acted in direct contravention to well-established law in the attempted conversion of appellant's constitutionally protected speech into a criminal act and in refusing to apply such well-established laws and constitutional limitation as a means to protect the police, while denying appellant's right to redress and due process of law. The magistrate, ROA.22-40653.495-496, figuratively stepped from the office of the judiciary, though in a legislative office, to charge appellant with unsubstantiated and inapplicable crimes on behalf of the state executive branch in direct opposition to constitutional separation of powers, demonstrating the dangerousness and the unfair treatment of indigent by 28 U.S.C. 1915.